AI content governance for law firms, protecting your brand in the age of synthetic media. What if the very tools designed to revolutionize your law firm's productivity could just as easily unravel its hard-won reputation? This isn't a hypothetical, it's the reality of generative AI in the legal world. As tools like ChatGPT, Grok, and Gemini flood the market with lightning-fast drafts and summaries, law firms face a critical question. How do you harness AI's power without letting it sabotage your credibility? Let's explore the tightrope walk between innovation and integrity in this new era of synthetic content. But here's where it gets controversial. The same AI that can draft a client memo in seconds might also invent case law or misinterpret jurisdictional nuances, without a single human checking its work. Imagine publishing a legal alert only to discover later that the cited statute was repealed last year, or that a referenced court decision never existed. These aren't just errors, they're reputational disasters waiting to happen. A recent high-profile example hit headlines in summer 2025 when a syndicated article in major newspapers listed fictional books as must-reads, all generated by unmonitored AI. The fallout? Public embarrassment, lost trust, and a stark reminder that machines can't replace human accountability. So, what exactly are law firms risking by leaning too heavily on AI? Let's break it down. 1. The accuracy trap. AI's infamous hallucinations, facts it makes up with unwavering confidence, are a nightmare in legal contexts. A single incorrect citation or misinterpreted case could lead to malpractice claims or regulatory scrutiny. Think of it this way: if your firm's name is attached to a flawed analysis, who's to blame when the client suffers consequences? 2. Plagiarism pitfalls. Most AI models learn by scraping vast chunks of the internet. While convenient, this raises red flags about intellectual property. What happens if your AI-generated white paper accidentally mirrors a competitor's work? Suddenly, you're not just competing on ideas, you're facing lawsuits for copyright infringement. 3. The dilution dilemma. Over time, AI-generated content risks eroding the unique voice that sets your firm apart. Clients hire you for your expertise, not generic templates. If every law firm's blog posts sound the same, how will you stand out in a sea of algorithmic sameness? 4. Internal leaks. Even internal AI drafts, like research memos or case summaries, can become liabilities if leaked. A poorly worded draft slipping into public view could paint your firm as careless or unprofessional, regardless of intent. Here's the good news: you don't have to abandon AI entirely. Instead, build a framework that turns its strengths into assets while neutralizing the risks. Here are 5 non-negotiable strategies. Human oversight mandate. Every AI-generated document, whether a client alert or a research memo, must be reviewed and signed off by a licensed attorney. No exceptions. This isn't just about accuracy, it's about accountability. Transparency first. Be upfront when AI is involved. Disclose its role in content creation, whether in footnotes or disclaimers. This builds trust and protects your firm from future disputes over authenticity. AI literacy training. Equip your team with the skills to spot AI's limitations. Can they recognize a hallucination? Do they know how to verify a source? Education is your first line of defense against reputational harm. Originality audits. Use plagiarism detectors and internal checks to ensure your content is unique. Even internal documents should pass these tests. Imagine the fallout if a pitch deck lifted from a competitor's AI output reaches a client. Brand voice guardrails. AI can mimic any tone, but does it know your voice? Define clear style guidelines and train the tool to align with your firm's identity. This isn't just about consistency, it's about preserving what makes you distinct. And this is the part most people miss: AI isn't the enemy, it's the tool. The real challenge lies in how you wield it. Used wisely, it can amplify your firm's ability to engage, respond, and lead. But let it replace human judgment, and you risk everything you've built. Your brand isn't just a logo or a tagline. It's the sum of your reputation, expertise, and trustworthiness. So ask yourself, would you entrust your career to a machine? Or would you make sure it works for you, not instead of you? Share your thoughts in the comments. Do you think AI should be a supplement, not a substitute, in law firm content creation? We'd love to hear where you stand. The risks of AI hallucinations in legal practice. Navigating the mirage of AI in legal practice, a critical examination. Imagine a world where the tools designed to simplify your work suddenly become a source of immense risk. This is the reality facing today's legal professionals who integrate artificial intelligence, AI, into their practice. But here's where it gets controversial. What happens when AI tools, designed to aid in legal research and drafting, end up creating fictitious case law or arguments? This phenomenon, known as AI hallucination, has already led to a series of judgments where non-existent case law was cited, causing significant professional embarrassment and legal repercussions. Legal practitioners owe a duty of care to their clients that encompasses verifying the accuracy and reliability of all legal submissions. When attorneys use AI-generated content without proper verification and this leads to adverse outcomes in court, clients may have grounds to claim professional negligence. This could potentially lead to both delictual and contractual claims for damages, especially if financial or reputational harm occurs. But what about the safety net of professional indemnity, PI, insurance? Typically, PI insurance protects attorneys from claims of negligence during their professional duties. However, the use of AI introduces a gray area. Insurers might argue that relying on unverified AI-generated content does not meet the standard of care required, potentially leading to a denial of coverage. This situation is further complicated by the unregulated nature of AI tools. Unlike human legal professionals, AI systems do not undergo licensing or adhere to professional codes of conduct. This lack of accountability could prompt insurers to exclude AI-related errors from coverage unless the policy explicitly includes such risks. To mitigate these risks, law firms are advised to implement strict AI in the courtroom, the risks of overlooking AI errors. Imagine a courtroom where justice itself is at risk, not because of a lack of evidence or a flawed legal argument, but because of a fake legal citation generated by artificial intelligence. Sound dramatic? Experts warn it's terrifyingly close to reality. And this is where the debate over AI in the justice system gets truly contentious. A recent controversy erupted when a Georgia appellate judge, Jeff Watkins, explained why his panel threw out a prior court order, an order believed to be the first ever overturned because it was rooted in bogus, AI-generated legal sites. The original case involved a divorce dispute. The order at the center of the scandal was drafted by the husband's attorney, Diana Lynch, a common practice intended to help overworked judges, but one now under a microscope as lawyers, and sometimes non-lawyers, turn to AI tools to assemble legal filings. The danger? Judges may inadvertently approve, or rubber stamp, decisions built on fabricated law. But here's where the situation gets tricky. Watkins observed that the disputed order relied not only on two fabricated cases, a telltale sign of AI hallucination, but also on two additional citations that had zero relevance to the matter at hand. Imagine being denied justice because a computer spat out imaginary case law. Lynch faced a $2,500 penalty after the wife appealed, and her further filings, apparently also crafted by Lynch, included a whopping 11 more citations that were, again, either fake or irrelevant. Watkins didn't mince words, calling Lynch's reliance on hallucinated cases to support her fee request, adding insult to injury. Yet, with all eyes on the ethics of legal AI, here's the most alarming twist: the court couldn't even confirm exactly how these fake citations appeared, whether AI directly generated the errors, or whether Lynch inserted them herself. This ambiguity raises pressing questions. How often are courts short-circuiting their own accountability? And how can anyone reliably trace responsibility when AI tools are at play? Should lawyers and judges be subject to stricter tech oversight, or will that burden be impossible to enforce? Watkins, for his part, suspects generative AI was at work. He underscored the significant harm that flows from submitting fictitious legal arguments. Not only does it squander time and money, but it threatens the very integrity of the justice system. Should a litigant ever suspect that a judgment rests on fake law, what's to stop them from questioning every court order? Think about the chilling scenario where someone defies a judicial ruling, claiming uncertainty over its legitimacy, a future no one wants. The Georgia case didn't end with clear answers. Instead, it set a cautionary precedent, no judge can afford to turn a blind eye to the risks of unchecked AI, even as the use of such tools grows. The initial order, now vacated, stands as a warning for the bench, and for everyone tracking the AI revolution in the legal world. Is this just a Georgia fluke? John Browning, a former Texas appellate judge and now a law professor, isn't so optimistic. He considers it frighteningly likely that more courts will unknowingly let AI-generated errors slip through. In a recent Law Journal article, Browning argued that lawyers' biggest sin isn't using AI, it's failing to verify its work, treating AI's output as gospel without independent validation. The problem, he warns, is intensifying. Trial courts, buried under heavy caseloads, may simply accept attorney-generated drafts, sometimes full of bogus AI citations, not just in divorce or family law, but in all manner of civil and criminal proceedings. The situation is made worse by the accessibility of AI tools like ChatGPT. According to the National Center for State Courts, these tools make it easier for non-attorneys and high-volume filers to submit cases, further overwhelming courts desperate to keep up. While AI-generated errors might usually be caught in high-profile disputes, what about smaller ones, or when people are too drained or too poor to challenge a suspect ruling? Is justice becoming contingent on who can afford to spot AI's mistakes? Some might wonder, aren't courts already sanctioning lawyers who misuse AI? The answer, yes, but it's complicated. Lawyers have indeed faced suspensions and fines for citing imaginary legal precedents, but judges themselves often escape with only embarrassment. And not all courts are responding uniformly. Some judges have introduced bans or disclosure requirements, expecting lawyers to specify which AI tool they've used. But with generative AI ever more deeply woven into legal research platforms, it's becoming harder, if not sometimes impossible, for attorneys to disclose their use transparently. Even requiring disclosures may not solve the problem, as Browning notes. AI is now so embedded within mainstream legal tech that attorneys may not even realize when they're relying on AI-generated content. Imagine a world where lawyers simply can't guarantee that every line is AI-free. Isn't it time for courts to revisit the very standards of tech competence? At present, only a few states, Michigan and West Virginia, have formally required judges to demonstrate tech competence in matters of AI. Others are setting up task forces or passing laws to ensure human oversight of AI-driven decisions, especially in criminal justice. But with each locality doing things differently, is a patchwork approach enough to keep the scales of justice balanced? Browning believes the answer lies in education. Judges and lawyers alike must become more savvy about AI's strengths and its many pitfalls, from phantom citations to subtle algorithmic biases. The goal? Arm judges with the knowledge to spot AI hallucinations, and avoid becoming overconfident in technology that still gets crucial facts wrong. This education can't come soon enough, especially as researchers begin investigating which AI models are most often used in legal filings and whether those models might, intentionally or not, be pushing certain interpretations of the law. Peter Henderson, who heads the Princeton Polaris Lab, is already planning research to map AI's influence in U.S. courts. He suggests that a simple, open-access database of case law could empower everyone, from lawyers to curious citizens, to quickly verify whether a citation is real or fake. Isn't it shocking that, in 2025, finding out if a case actually exists can require jumping over paywalls and sifting through scattered databases? But here's the part most people miss: the solution might be gaming the system in judges' favor. Dotsa Greenwood, co-chair of MIT's Responsible Use of Generative AI for Law Task Force, floated the idea of a bounty system, paying lawyers or court officers who catch and report a fabricated case first. If implemented, this could not only discourage hasty or careless AI usage, but also relieve judges from having to function as full-time AI detectives. Still, Greenwood admits, such rewards for catching AI errors might not eradicate the problem. Would the certainty of being checked finally convince some lawyers to cut fewer corners, or would it simply add a new layer of bureaucracy? While researchers work on AI-powered detector tools, judges can still look for red flags. Case number like 123456 should always prompt suspicion. AI also often misattributes regional case reporting.